Chair, and it's great to be here. And thanks for the plug on the book. I am really honored here to be here with Tim and Maureen, who have both had a hugely influential careers, but we have a lot to talk about. So I'm only going to touch on my introductions on the things that are probably the most relevant to this conversation. Tim Miras is a George Mason University Foundation Professor of Law at the Antonin Scalia Law School, a visiting senior fellow at AEI, the American Enterprise Institute, and senior counsel at Sidley Austin, where he, of course, focuses on antitrust, consumer protection, privacy, and cybersecurity issues. He was the chairman of the FTC from 2001 to 2004, very relevant to our conversation today. And he also, I think, perhaps uniquely, served as the director of both the Bureau of Consumer Protection and the director of the Bureau of Competition at the FTC. And we'll talk a little bit about those two missions and what they're looking like at the FTC now. And I'm particularly honored to introduce Maureen Olhausen, who's my mentor, my friend, and my former boss. She is the chair of Baker Bott's Global Antitrust and Competition Practice, where she focuses on, again, antitrust, and especially investigations and litigation involving antitrust, privacy, data security, and consumer protection. She was the acting chairman of the FTC under President Trump, and she was a commissioner of the FTC under Presidents Trump and Obama. Like Tim, she had a very distinguished career at the FTC prior to being a commissioner. She was the director of the Office of Policy and Planning from 2004 to 2008, where she did some great things, including the Internet Access Task Force. And she served as an attorney advisor for an FTC commissioner from 1998 to 2001, which I can say is an awesome job. She had several other roles at the FTC as well, but we're going to jump directly into talking about the FTC and Flux. It's a time of change at that agency. We have two of the best people, I think, to talk about that. And so I just want to tee this up by talking about the justifications for agencies and for the FTC in particular. The nominal justification, and in fact, the one that Woodrow Wilson offered when establishing the FTC, was that it would be a bulwark of expertise against popular sentiment. Then that administrative agencies would be sort of separate from the political process. But that doesn't really talk about the subject matter of the FTC. And so I'm curious, how would you describe the FTC's expertise, why it exists, and in particular, what role does it play in regulating the tech industry? And maybe Maureen, I'll go to you first.
There we go. Can you hear me now? Excellent. And I do want to plug, I don't know if you see this, Neil, Neil's book here. But anyway, so the FTC was created during really the last progressive era with the idea that it would be a body of experts who would give content to essentially unfair methods of competition. So when the FTC was created, it only had authority over unfair methods of competition, and it would, on a bipartisan basis, bring cases, do reports, kind of share its expertise, and give content to this, so that in a forward-looking way, going forward, companies would know, okay, what is a fair way to compete and what isn't. And it was brought into play because of frustrations with the Sherman Act on the competition side and sort of a cramped view of the Sherman Act. It was given these kind of scholarly powers. That was something that was kind of unique to the FTC, and case-by-case enforcement with more limited remedies to sort of say, like, well, going forward, companies, stop doing these bad things and start to behave. It, I think, tried to use its unfair methods of competition authority very broadly to start challenging what we would consider consumer protection violations, on the idea that if a company engaged in deception, it gave it a leg up over its honest competitors, and therefore that was an unfair method of competition that eventually got struck down by Congress. And in 1938, in the Wheeler-Lee amendments, the FTC was given its unfair and deceptive acts or practices authority. So that's kind of the source of the two hats that the FTC has. It's antitrust competition authority, and it's consumer protection, deception, unfair methods authority.
Tim, how does this play out across companies, and in particular the tech industry today? What is the FTC's role, sort of status quo?
Well, look, we've had, as Maureen mentioned, and thank you for inviting me here today. We've had these various episodes of populism. I'm doing a project with Jeff Eisenach for AEI on the populist history of antitrust, where actually I think you can count them various ways, but as we count them, we're in the fifth episode. And until a few years ago, people on both politically, Democrats, Republicans, regarded antitrust to be in a bipartisan island. Everybody agreed it was going well. And then suddenly we have people who call themselves neo-Brandisians with a focus on big tech, who want a revolution. And the President Biden declared the last 40 years were a failed experiment. And we can talk about where that leads us as to what happened before the last 40 years. But because the focus is on big tech, and we're talking about, in some cases, they not only want to regulate, they want to dismantle the companies. Ironically, both the FTC and the Justice Department had already, in the Trump administration, brought major cases, one against Google by Justice, the other against Facebook by the FTC. But it's clearly, and there was an emphasis on big tech, but if you look at the president's executive order where he made this speech, this goes way beyond big tech.
So let's talk a little bit about the transformation of the agency. I think chairmen come into the agency with an agenda. I'm sure both of you did. I know it for a fact. And they pursue those agendas, but it's, as one person described, Chairman Lena Khan's agenda, that it looks like move fast and break things, which is something we think about in the tech space a bit more than maybe past leaders. Both of you have mentioned the history of the FTC, and so I'm curious from your perspective, how unique is this period right now, and in particular, in some of the actions that the agency has taken? What are some of the general themes that you see across the actions that the commission has taken since Chair Khan joined the agency?
Tim, you want to go first? I went first last time.
Okay, sure. Look, I'm a big fan of Ken Burns, and he likes to quote Mark Twain, who said, "History doesn't repeat, but it rhymes." And I think we got some serious rhyming going on here. The chair, Lena Khan, has only been there since the middle of June, and most of what she's done is procedural, limiting bipartisanship and aggregating power to herself. But if you look at what they propose to do, a lot of it is a return to rulemaking, and rulemaking was a very big theme in the 1970s. It came to very little, but at one stage, the FTC proposed 16 major rules in 15 months. And these were rules that were meant to transform entire industries, and they involved basic aspects of everyday life, essentially almost from birth to death, literally. And they, although they haven't said exactly what they want to do, they have made it easier to do rulemaking, and so that will be a significant part of it. They've also talked about things that in the failed 40 years were regarded as verboten, like the Robinson-Patman Act. The Robinson-Patman Act was the statute passed in 1936. It was the bane of antitrust law. It was aggressively anti-consumer and pro-small business. It took a long time. Fortunately, in the end, it was written very vaguely and the courts defanged it. But it was the major antitrust policy of the FTC in the 1950s and 60s. And Lena Khan is the only, and the neo-Brandesians are the only people since the 1960s in the antitrust world who have spoken favorably about it. And that's just one of many examples of things that were rejected. Railroad regulation is another one. That they now speak favorably of. And so, we're about to see what will happen.
So are there any ways in that what's happening right now, the rhyme is radically different, or is this sort of a repeating? And in particular, what can the agency do under its own power without additional work from Congress to do something like revive enforcement of the Robinson-Patman Act? Maureen?
Well, I do think this turn towards rulemaking and regulation and away from some of the more, I would say, consensus-driven antitrust. So you look at antitrust law, right, as it has been interpreted. And the FTC has essentially, for many years, said, well, what's an unfair, if something violates the Sherman Act or the Clayton Act, it's an unfair method of competition, right? So there was this consistency between how the FTC enforced and the Department of Justice enforced antitrust law. But there were, there's things in current antitrust law that the progressives don't like. And those two of those things are the consumer welfare standard, the idea that antitrust is supposed to be directed towards consumer interests and not wider societal interests such as labor or favoring small business over large business or environmental concerns or things like that. And that antitrust has really moved towards a rule of reason approach, right? Where you test a business behavior and say, well, does it actually hurt? Does it actually reduce consumer welfare, or is it likely to reduce consumer welfare? And it's not just limited to price. They often say it's limited to price. It's not just limited to price, consumer welfare, or the rule of reason. So what we're seeing is through this new kind of embrace of rulemaking and other sort of regulatory approaches, moving away from the consumer welfare standard. The Robinson-Patman Act would be a prime example of that, kind of bringing that back. And the rulemaking, I think, also moves away from the rule of reason approach. And so some of the petitions for the FTC to engage in rulemaking, so these are not that the FTC has put these forth, but others have put this forth to the FTC, and now they put those out for public comment, would move away from both of these important guideposts in antitrust law. And I think, for some people, they feel that antitrust has become too difficult to enforce. So they see this as sort of a path that sidesteps those things. And of course, it creates a lot of questions about, well, you have a dual enforcement system, and what does unfair methods of competition really mean? Does it mean, when it was given to the FTC 100 years ago, maybe it was broader than the Sherman Act, but the Sherman Act is a lot broader than it was 100 years ago. Is unfair methods of competition forever wider than the Sherman Act, or does it run into some barrier at some point? So these are some really important questions that I think are going to come up. But I do see, kind of this push towards sidestepping those antitrust issues through rulemaking and unfair methods of competition.
Yeah, if I could follow up on that for a second, it's a great point that Maureen is making about the difference between the two antitrust agencies. Bob Pitofsky, who was my predecessor, and is one of the interesting things about saying the last 40 years are failed is President Biden is throwing under the bus the Clinton and Obama administrations as part of that. And Bob Patofsky was, until very recently, regarded as a great FTC chairman. He didn't believe in interpreting the FTC Act differently than the Sherman Act. And the reason was, if you did, and they clearly believe they want to do that now, you are saying that the rules for your company are different simply because of which agency investigates you. And that's, that is really dangerous. And that's the point. That's the great point that Maureen is making.
Right. That adds a lot of arbitrariness to you. Basically, it's the two agencies debating in the back room about what rules they're going to apply to various cases, which adds a lot of arbitrary nature to enforcement. In addition to the difference between DOJ enforcement and FTC enforcement, what else is a downside, or what are some of the challenges with rulemaking at the FTC? Tim, you mentioned that the FTC tried to do a bunch of rules in the past, but what happened to those? Why did it sort of move away from that method? And what are some of the downsides of bringing that method of rulemaking back, in addition to the difference with that DOJ?
Yeah, I was involved in the last turn at the FTC in the Reagan administration. Now, look, the FTC was going to have to turn in any event, because if you look at the FTC's court record, for example, it was what happened is the academy changed first, then the courts and the agencies changed last. But the FTC won virtually all of its cases in antitrust that were filed in the first half of the 70s. In the second half of the 70s, it lost 2/3 of them. And we're not talking about now where just a few cases were filed a year. We're talking about 40, 50 cases. And the agency just wasn't listening. And on the rulemaking, on rulemaking, what happened was they would do rules, and there's a piece that I wrote in Regulation Magazine called "Rules Without Reason." They would do these rules, and they wouldn't have a very good idea why they were doing the rule, and that they would have almost no idea in the published materials of why the remedy would fix whatever the problem was. And since the problem was very vaguely specified, it was a recipe for disaster. And so most of the rules just kind of sunk of their own weight, and only very few got out the door. And the ones that did get out the door in very skimmed down fashion. And
Maureen, I know you've talked about this in the past. I wonder if there's 2 points on rulemaking that you might address. Sort of Congress's reaction, the public reaction to what the FTC was doing in the 70s, and what that might say about today. But then also, I know you have a recent paper on the legal authority to do rulemaking in this space. And so I wonder if you might just touch on those 2 points.
Certainly. So the FTC didn't really engage in rulemaking for the first, 13, 14 till like the late 60s or early 70s, right? So, and it often said it didn't have rulemaking authority, right? There was a little piece in the act that suggested that it could make rules, but more for like internal processes. It's got an internal administrative litigation capability. Well, that kind of in the previous kind of embrace of rulemaking as like, oh, this should be a great thing, sort of government wide, the FTC issued a joint rule on, it was called the Octane Rule, and it was a joint competition consumer protection rulemaking. And it said that if gasoline retailers didn't post the octane rating on gas pumps, that it was an unfair method of competition and an unfair deceptive act of practice. And that got challenged. And the DC Circuit upheld the FTC's rulemaking authority in a very, very broad kind of interpretation. It didn't unpack unfair methods and unfair and deceptive acts or practices. It essentially said, we kind of think rulemaking is a good thing, and the statute doesn't say the FTC can't do it. So in reaction to that, Congress got involved and it issued the Magnuson-Moss Warranty and Federal Trade Improvement Act to explicitly give the FTC rulemaking authority, but it only mentioned unfair and deceptive acts or practices. And it explicitly said, this says nothing about unfair methods of competition. And what it did was give the FTC this rulemaking, but with a lot more procedural hurdles or safeguards, maybe is a better way to put it, guardrails in place. So it's not streamlined APA notice and comment rulemaking. There's a lot more things that the FTC has to do. So then the FTC kind of took that and ran with it and did a whole bunch of rules. And I think Tim was talking about some of these all consumer protection oriented rules that led up to kind of a crisis in what we call the KidVid rulemaking, where the FTC tried to outlaw the advertising of sugared cereals to children with the impact of essentially getting rid of the funding source for children's programming. And that led to the even the Washington Post calling the FTC the national nanny. And then Congress stepped in again and put some more restrictions on and actually defunded the agency for a while and was obviously very displeased. So the FTC then turned away from rulemaking after that, except for where there were statutes such as the Children's Online Privacy Protection Act, where Congress gave the FTC a lot more guidance about what its goals were and where the lines were going to be drawn and how it was going to work, and then gave the FTC limited rulemaking authority, but more streamlined APA rulemaking authority to kind of update the rules and keep them up to date, particularly involving technology, things like that. So that was kind of the state of affairs until now. You have Chair Khan wrote an article with former Commissioner Chopra that said, well, what the petroleum retailers case said and what Magnuson-Moss means is that the FTC actually has unfair methods of competition rulemaking without these Mag-Moss limitations on it, that it can just be the streamlined APA notice and comment rulemaking. So that's what they are wanting to do now. I think they actually probably want to do both kinds of rules, or maybe even a combined rule, but with the idea that, well, now they can enact UMC stuff much more expeditiously. I have an article I co-wrote with Jim Rill, former head of the Antitrust Division at the Department of Justice, unpacking that and saying, well, first of all, kind of congressional silence doesn't mean acquiescence to a court decision about whether the FTC has that authority, and that under modern statutory analysis, the FTC statute would not support finding this kind of rulemaking authority. When you looked at, for example, the AMG case, recent 9-0 case by the Supreme Court, applied a much more rigorous screen to what does the statute say and what is the structure of the statute to decide whether an agency has this kind of implied power to do things. And so we believe, Jim and I or advocate in our paper, that the FTC under a modern interpretation would not have unfair methods of competition rulemaking, was not endorsed by Congress in the Magnuson-Moss Act, and that therefore this is not a strong ground on which to move forward with UMC rulemaking.
Yeah, it seems like administrative law has changed a little bit since the court said that, well, they didn't say anything in the statute about rulemaking, so they must have it. I think that would surprise many administrative law lawyers today, and that suggests that to the extent there's barriers, they might be bigger than just barriers to what the FTC wants to do. They might be a bit bigger than just the existing antitrust laws. So
yes.
On on that front, the FTC does seem to be changing tactics right at a time when courts have already been increasingly skeptical of its existing authority on the remedy side, as well as some other areas. How is the FTC likely, we talked about the interaction with the courts in the past with the Robinson-Patman Act. How are courts likely to view these big changes, including some of the procedural changes that I think are kind of under the radar because they're really wonky, that streamline things? How are courts likely to view this, given that they've taken a somewhat skeptical view of the agency's existing authority right now? Tim, I don't know if you want to jump in on that.
Sure. Well, look, one area, there's a lot to your question, but look, one area that will attract them and already has attracted them, as Maureen mentioned before, is the U in both unfair methods of competition and unfair deceptive acts or practices. And this siren song goes all the way back to 25-year-old Richard Posner. Dick Posner worked at the FTC. Everybody's worked at the FTC at some time, it seems. And he wrote he worked for Phil Ellman, who was a very famous FTC commissioner. And of the three, there are three really famous rules in FTC history. And the cigarette rule was the first. And it led to Congress passing a law that put cigarette warnings on cigarette packages. And Posner wrote what became this three-part cigarette rule test that was adopted by the Supreme Court on March 1st, 1973, which was one of the worst days in FTC history in retrospect, because it encouraged the agency to launch this rulemaking binge. And it led to ultimately a statutory definition of the U in unfair deceptive acts or practices. But they are already thinking about how they can push that and the U in unfair methods of competition. In 1977, the chairman, Mike Perchuk, got Robert Reich, who became Secretary of Labor in the Clinton administration, with a very talented staff. I could tick off the names and the careers of a bunch of young people who worked there, to try to explore the boundaries of unfairness. And it blew up in smoke when the chairman said they could use unfairness to deal with environmental harms and corporate malfeasance of all sorts. And it was part of what blew up. But I would not be surprised if we see a repeat of that, to try to figure out how to explore both U's to push beyond the Sherman Act, which again, something that Maureen was suggesting before. And especially if they do it in rulemaking, they think they can get deference. Courts give more deference to rulemaking. I think that's the play.
So, you mentioned that integration, and Chair Khan recently had a memo to staff that talked about the visions and priorities for the FTC, and she called for an integrated approach to cases, rules, research, and other policy tools, and breaking down the barriers between the silos between consumer protection and competition. First, maybe you could talk about your experience with the FTC and how siloed those two groups are, but what are some of the other practical challenges and likely consequences of blending the consumer protection, competition tool set and using the agency's power as reaching for whatever tool they can get? Maureen?
So one of the issues there, as I already mentioned, the FTC started out only with unfair methods of competition rulemaking authority, and it had to get new authority in the Wheeler-Lee amendments to get unfair and deceptive acts or practices. So that shows they are separate, right? They are separate authorities. They meant to do different things. On deception and unfairness, the UDAP is meant to address individual issue, transactions with consumers, right? You made a promise, you didn't fulfill it. I wouldn't have bought this product. or you engaged in an act or practice that caused me substantial injury that I couldn't reasonably avoid, and that's not outweighed by countervailing benefits to competition or consumer protection. So there's no market power test. There's no rule of reason other than some balancing, sort of a balancing test in unfairness. So one of the issues here that I'm a little concerned about is kind of remixing these things back together. Is if it is being done with the idea that you can take what is essentially a consumer protection violation and turn it into an antitrust violation by saying, oh, therefore you don't have to, or really it kind of goes both ways, or take an antitrust violation, turn it into a consumer protection violation, again, to get around some of the stringent tests for an antitrust violation, like market share, like, again, going back to the rule of reason, to sidestep the rule of reason. The idea that you could say, well, if you are a company and, maybe you're a big company, and you engage in, some sort of deceptive act or practice, it gives you a leg up on your honest competitors. So therefore, it's an unfair method of competition. But we don't have to show that you are dominant. We don't have to show, the other tests that we might have to show to meet a Section 2 violation. So that concerns me, that we're going to, again, kind of use this as a route to sidestep antitrust case law that they find unappealing. Then the other thing that kind of going the other direction is antitrust has some very powerful remedies, including, divestitures, right? And breakups and things like that. So will they, through this melding, try to say, well, you've engaged in, consumer protection violations. And we think the remedy for that is that you have to separate your lines of business and spin things off, or you can't engage in, self-preferencing. You can't get, I think a lot of the kind of things that are being discussed in Congress to put into antitrust bills. And the idea being like, well, no, we're just going to kind of find a different route to do this by shaking together antitrust and consumer protection and picking the pieces that we like best and putting them into kind of a new hybrid theory.
So, on this interdisciplinary approaches, Tim, you've said when you were chairman that economics is antitrust's most notable interdisciplinary attraction. And what do you make of the fact that this memo on the visions and priorities for the FTC doesn't even mention economics? It doesn't mention the Bureau of Economics. What does that say about the approach of the chair to consumer protection and competition issues?
Well, the neo-Brandesians don't like the consumer welfare standard. They think it's too confining. They misconstrue it. But look, they have this whole, the whole 40 years is, the whole failed 40 years is a fictitious thing built around attacks on Robert Bork. I do this shtick when I go in front of audiences where I ask antitrust lawyers, in your practices, how much do you use the Rita Hovenkamp treatise, and compared to Bork? It's like 100 to 1. Bob Bork was very important, and the Chicago people. I wrote an article about the Chicago School where I started with Ruth Kobayashi. We come both to praise and bury the Chicago School of Antitrust. Chicago School of Antitrust was enormously important in getting rid of the craziness of the 1960s and 1970s, but that was 40 years ago. The Chicago people most of them had no vision for how to do antitrust on a day-to-day basis. And it's because they were writing against this nutty stuff. I would put on the board three things about merger policy. The first one was we'll stop mergers presumptively with a 4-firm share of 60%. The second was 3 is enough. And the third is the marginal case is 6 to 5. Question, which one is Chicago? The audience would say 3. And I said, you're wrong. It's a trick question. They're all Chicago. One was Posner, one was Bork, and the other was Bill Baxter. And they couldn't be farther apart in the antitrust spectrum. It's just an example that there was no Chicago position on mergers. There was no Chicago position on predatory pricing. There was a Chicago position on a few things. And it's because there was a Chicago position on getting rid of the garbage. The Chicago school was like the famous analogy of Thomas Jefferson and John Adams, who were together as close as you could be on getting rid of the British. But when it came to running a government, they didn't agree. But of course, in 1776, they weren't worried about running a government. They were worried about getting rid of the British. It was only in the 1790s that they disagreed. And so the Chicago people didn't come into this. What they're criticizing is when the Chicago people weren't talking about running government. The people who matter just as much, if not more, about modern antitrust law are Phil Arita, are people from Harvard. Stephen Breyer is the most important justice on the Supreme Court. And he's someone that they're throwing under the bus too. Like I said, they hate transportation regulation. I met Stephen Breyer in 1975 when he was convincing Ted Kennedy to support transportation deregulation. And one of the things that they have actually started on now in the executive order is re-regulating the railroad industry, for God's sakes. No one across the antitrust spectrum until very recently would have had anything good to say about the old transportation regulation. And in that report that Lena Khan was involved with, the big House report that came out last fall, a dozen times they praise railroad regulation. It's an amazing example of how they praise this history that had been almost unanimously discarded.
And discarded by economic analysis as well.
Correct. But almost everyone across the antitrust spectrum in the so-called failed 40 years, including, like I said, the Obama and Clinton administration.
So you raise an interesting point about Chair Khan's role on the Hill. And in many ways, it's relatively common for people to go from Hill positions to agencies. We've seen that. And I think the current commission may have 3 commissioners who are in that role. I don't think they agree with each other on everything, for sure. But I do wonder if maybe you could. Let me take this question a couple different ways, but we've talked a little bit about the interaction of the courts, and we've talked about Congress doing things in reaction to the FTC. How much more politicized is the agency now than in the past? And is that an effect of how Congress is interacting with the agency? And what could Congress do better to help the agency pursue its mission properly?
Want me or Tim to answer that?
I've been talking too much, Maureen. Why don't you go ahead?
You have not, but so you raise a couple interesting issues there. One that I think is this idea that antitrust should move away from the consumer welfare standard, and it should try to include all these other factors, right? Labor or environmentalism or things that, and we're hearing from practitioners at the FTC in merger, reviews and second requests are asking about labor issues and broader than just consumer welfare oriented questions, inherently makes antitrust a more politicized endeavor, because it is not simply saying, okay, here's the thing that you're supposed to pursue, and you pursue that. It's getting you to weigh things in a way a legislature should really be weighing things, right? So how do you weigh labor interests over consumer interests as an antitrust enforcer, right? The agencies aren't the Department of Labor, right? And Congress makes detailed and statutory provisions for labor and things like that. Has a whole agency that applies that. But now to kind of import that into an antitrust analysis, I think makes it just inherently more politicized. I also think that, one of the things that we had previously around this more consensus view that antitrust was supposed to be focused on consumers, we're supposed to look at economic analysis, and that we, looked at the rule of reason, basically followed the law as the courts had set it out, that there were sharp disagreements. I had sharp disagreements with my Democratic colleagues, and, Tim, I'm sure, had some from time to time, but there was a core consensus that allowed for transparency and predictability in enforcement. That when you counseled companies, you could, generally say, I think this deal is going to raise big problems, or I think this deal is going to get through. One of the things that we're seeing now is that the FTC, they've stopped early terminations. So the least problematic deals, don't get sort of triaged out. They are telling people that they're at the end of the 30-day review period under the Hart-Scott-Rodino Act, that they close at their own risk rather than the agency kind of, moving things along. And they are trying to create a lot more uncertainty and difficulty in mergers, which again, I think creates this sort of political issue where Congress enacted the Hart-Scott-Rodino Act. Congress decided sort of where the boundaries were going to be and the structure. Now, certainly any merger, just because it didn't get reported under Hart-Scott-Rodino, or even if it didn't get, reviewed, that doesn't mean it gets a free pass forever. The agencies can always go back. But the FTC sort of unilaterally is trying to change those lines. And so that is, again, kind of a politicized process versus, adhering to where Congress set the rules. So I think that also raises, makes it more difficult, certainly makes it more difficult to achieve a bipartisan approach. And that was one of the real hallmarks of the FTC. It's bipartisanship that, I think would be a shame for that to be sort of devalued.
Well, it's interesting. Many of those things that you talked about, we hear often that the FTC is overloaded. I think they've been, we've heard that for a long time, but I think this chair has pointed to that more so. And in particular, but some of the things that you're talking about are things that sort of are self-inflicted, right? They're increasing their workload. And to the point that if they lose in court on some of these, or if they reduce the incentive of companies to essentially settle cases before going to court, that's just going to increase their workload even more. So I don't really have a question. It's just more of an observation on that point. I do want to get to a great question in the from the audience, which is the question is about the neo-Brandeisians are really against monopolies. Is there any chance that there's going to be a home for this agency to look at government-created monopolies? Maureen, you created a task force on occupational licensing, and Tim, I know you also did under your leadership. The FTC did a lot of work in government-created monopolies, and so is that something that you would think maybe the neo-Brandeisians would be interested in that? The chair might be interested in that. How do you see that playing out and the FTC's role in that now?
So I think there's one bright spot there, which is the executive order did focus on reducing unnecessary occupational licensing barriers. So, interestingly, a lot of when I was the chair and I, had my economic liberty task force, I did get criticized from certain quarters, and it had been something that was actually had a lot of bipartisan support previously. And Tim did wonderful work on the state action doctrine, kind of clearing the way to be able to challenge some of these, as they were under the cover of government, they were actually private entities doing this, the private actors doing this. So I think there, is some glimmer of hope there, but that hasn't made it, while it's in the executive order, it hasn't made it into the priority list of the FTC, not at least that I've seen. Tim, feel free to weigh in.
Yeah, well, an interesting point about the neo-Brandeisians. Louis Brandeis was not just against big companies. He was against big government, especially big federal government. And that's, I'm glad they're going after occupational licensure, and that was a great thing that Maureen started. And I wish it had been pursued more vigorously after she left. But the disdain of big federal government that Louis Brandeis had every bit as much as he disdained big business. And Louis Brandeis voted against some of the stuff the Roosevelt administration did that led FDR to try to pack the Supreme Court. That is not part of the neo-Brandesians, unfortunately.
So, we've talked a lot about the, well, maybe we could, we're getting close to time, and I want to get some more audience questions in, but I know, Maureen, I believe maybe under Tim, I might not have this history exactly right. You led the work, that might've been under Kovacic, on the FTC at 100 report, which tries to draw some lessons from the FTC's history about how the FTC can be effective. And I remember one section of that talking about having a focus objective. And I wonder if both of you, what sort of advice would you have for achieving the FTC's goals in a really complicated, it's a complicated agency, it's a complicated world to navigate. It's really important tasks to protect consumers and to promote competition. What is some of what advice would you give on how to think about leading an agency like that?
Tim, you want to go first?
Sure. Look, I would have a couple pieces of advice. One is these procedural wrangles that they're having are not doing anyone any good, and in fact, I think it's hurting the new leadership politically. They ought to be fighting over substance. There's plenty to fight over with substance, and not fighting over trying to prevent the Republican commissioners from reading documents and getting documents. They ought to try to return to more regular order in how the commission works. The second point is in any one of these jobs, and I've had 6 jobs in the federal government, you need to hire complementary parts. And there are lots of administrative law experience, lots of Democrats in the DC bar who I think could help these people in what they want to do in a way that will make it easier for everyone to deal with the FTC. I suspect there's some concern about hiring experienced lawyers who work for companies, but I don't, there's just nothing wrong with that. And that's that kind of experience you need, especially when you're young. I was the same age that Lena Khan is when I was director of the Bureau of Consumer Protection. And one of the things I did was hire some very experienced people. We wanted to bring fraud cases. I couldn't have brought a fraud case of my own if you put a gun to my head. And I hired some very good people. It turned out, because I was a very young male, it was in some ways easier to hire, more experienced women. They were more willing to work for a young male. But I had tremendous people of both genders. And I probably just said something politically incorrect in the modern age, but in any event, hiring complementary parts would be my second piece of advice.
That's, I think, completely agree with everything that Tim said. I think it's, Neil, you mentioned the FTC at 100 report, and understanding and embracing kind of the unique role and structure of the FTC, I think, is important. It's a small agency. Even if it gets some of this plus up, it's going to continue to be a small agency. But it can do really, really important things when it embraces its unique capabilities. So the case-by-case enforcement there was that, I did a big study about the FTC's administrative litigation, and Neil, you were there, and you helped me with that. But one of the things it really showed was how the FTC's administrative litigation, right, which doesn't always, get the glory that it deserves, has had a big impact on antitrust law and a big impact on Supreme Court victories for more antitrust enforcement, right? So Phoebe Putney, North Carolina Dental, Indiana Federation of Dentists, kind of the list goes on. And so one of the things, so you mentioned the AMG case, and Justice Breyer wrote that case. And it cited a speech I had given a number of years ago called Dollars, Doctrine, and Damage Control, How the FTC's Pursuit of Disgorgement Affects its Antitrust Mission. And what that speech was about is how the FTC going into federal court in pursuit of money actually undermined its ability to improve antitrust law, improve the enforcement of antitrust law. So I would encourage the agency to kind of go back to its roots, to try to, rather than through rulemaking, and especially UMC rulemaking, which then is only limited to the FTC, that it actually go back to bringing well-rounded, economically reasonable antitrust cases through its administrative litigation and getting that kind of taken up into the antitrust case law. And so one thing that I will give Tim, among the many things that Tim deserves enormous credit for, is something very, very key that he did in light of real difficulty in antitrust enforcement in hospital merger area, where the FTC and DOJ, I think, lost 8 hospital merger challenges in a row. And courts were just not believing, right, the agency's prediction of anti-competitive outcomes. So Tim did some wonderful work. I think it was retrospective, a study and it showed that these bad effects were happening. And through administrative litigation, kind of aired that out. And then the agencies, both of them, have had wonderful success rate in hospital merger challenges. So I think that's a really important thing, because so often it's painted as, well, you don't want to do antitrust enforcement. You don't, you're not interested in that if you don't embrace all these, real sea change at the FTC. And I don't think that's right. So one of the things that I would say is, understand the FTC's unique capabilities and embrace it and move forward. Now it's incremental, right? And that's the thing I think people get impatient with. But when I think about, for example, I supported the McWane case, an important administrative law case about exclusive dealing. And we won that case in the 11th Circuit when I was at the FTC. And I think that laid down some really key case law, but it wasn't overnight. So that would be my, one of my recommendations is, to kind of move with economic grounding and embracing those FTC strengths, because in the long term, they have really paid off for good antitrust enforcement in the US, and not a one-way ratchet to say no antitrust enforcement.
Right. This actually tees up nicely with a question from the chat. In some ways, when you look at the rush to do rulemaking, or the potential rush to do rulemaking, it looks like trying to do something that the FTC hasn't been historically successful at, and may not be particularly well equipped to do even now, given that it doesn't have a lot of practice doing rulemakings. So maybe I already answered the question, but the FTC has done some rulemakings. It has a history of doing case by case. Maybe that incremental approach, and as compared to a sort of more sweeping rulemaking, do you see that as a way that Chair Khan is ignoring the specific capabilities of the FTC, or trying to remake the capabilities of the agency into something different than what it is now? And is that going to work given their track record?
Well, let me start. I think that's a lot of what I meant by complementary parts. I mean, I was moving away from rulemaking. They're moving toward rulemaking. I couldn't do it by myself. I don't think they can do it by myself. There's a wealth of talent. I mean, I wouldn't do it, but they're in charge, and there's a wealth of talent they can find. And I think it would, I mean, it could backfire in one sense, but it would be, I think, in another sense, I mean, backfire in the sense of it, they might have more success, and I'm substantively that would bother me. But I think it would actually, I think many of their ideas are so crazy they're not going to work in any event. But it would, getting people who know how to do rulemaking and to try to structure the rules in a way people can confront the issues substantively would probably be better for all of us.
Well, we're coming up on time, and I just want to tee off of that. We touched on that a little bit earlier, but if the agency is trying to do crazy things, and people outside of the agency are looking at it and thinking that, does it undermine the agency's credibility? And does that matter with an enforcer? Does an enforcer need credibility with the firms that it enforces against in order to be effective?
Well, yes, right. Because if you're going to have threats that we're going to litigate, we're going to bring this, we're going to bring that, I mean, that only goes so far, right? Firms will say, well, you agency could say A, B, or C, but in the US, our system is Congress writes law, the courts interpret the law, and you enforce it. But if your enforcement is out of step with the way the laws were written or the way the courts have interpreted those laws, there's much less ground for agreement. And I think there's much more incentive to say, well, we'll see what the courts say about that. So I think, that you can only push it so far. And look, we saw that in the AMG case, right? There were lots of courts of appeal who said, oh yeah, the FTC has, redress authority under 13B. And one defendant said, I disagree, and brought it all the way to the Supreme Court. And the court unanimously said the FTC didn't have that authority, right? So I do think that, the courts are the ultimate backstop in our system. And I think that's a good thing.
Well, we're close to time. I wonder if there's any, just concluding couple of sentences that you two would like to leave the audience with about the FTC and its future.
Yes, it will be interesting to see. One of the reasons that the craziness of the 70s was stopped is the business community reacted negatively. It'll be interesting to see how the business community reacts this time. One of the surprising things to me was that the neo-Brandesians were disparaging the Obama and Clinton administrations, and yet a large number of Obama and Clinton officials were not defending what they had done. Now that they've been branded as failures, more of them are starting to react. But that was a different attitude than in the 70s, and it's going to take business community pushback, and we'll see.
Yeah, and just my parting thought is that look, the FTC, its history of bipartisanship, and also very capable career staff who've done, I think, a very good job over the years, are two, unique aspects of the FTC that I, am worried or being sort of undervalued. And so I would hope maybe there'll be a turn back towards appreciating those things as strengths of the FTC and not weaknesses.
Great. Well, this was entirely fascinating for me. I'm sure it was for our audience. Thanks so much, Maureen and Tim, for joining us today. And thanks to NetChoice for putting on this event. I had a great time. Thank you very much.
Thanks for having me.
Lots of fun.
Good to see you, Maureen, and guys, Neil.